floor is currently yours. You have 5 minutes.
Thank you. Mr. Chair and honorable members of the committee, thank you for the opportunity to testify as part of a panel of witnesses in the study of Canada's sanctions regime. Tamil Rights Group is a not-for-profit human rights organization acting globally to support Eelam Tamils. We relentlessly pursue means to uphold human rights through global diplomacy, together with legal avenues under international law and human rights principles. In November 2021, TRG submitted a major communication under Article 15 of the Rome Statute to the International Criminal Court, requesting a preliminary examination into crimes against humanity committed against Eelam Tamils within territories of state parties to the ICC. Canada recently imposed sanctions related to Sri Lanka under the Special Economic Measures Act in, I quote, response to the gross and systematic violations of human rights occurring in the country. Sanctioned under CEMA were 4 Sri Lankan state officials who were responsible for gross human rights violations which occurred during 1983 to 2009 and afterwards. This was a great step in exposing the atrocity crimes, including genocide, that Tamils have been facing at least since 1948, and including the anti-Tamil pogrom of 1983, and most recently the 2009 Mullivaikal massacre. Numerous Tamils, including women, children, and surrendered unarmed militants were brutally murdered in the massacre, and death toll estimates range anywhere from 40,000 to 150,000. I am here today not only as a representative of Tamil Rights Group, but also a victim of the 1983 riots, which forced my family to migrate to Canada in 1985. Today, I would like to highlight TRG's view on Canada's sanctions regime and provide recommendations on how Canada can further strengthen the current regime. These recommendations are made in consultation with our legal advisors, David Mattis and Sarah Teach. Our first recommendation centers around greater transparency and more involvement from civil society and NGOs. We feel that there should be a clear and formalized pathway for NGOs to communicate requests to implement sanctions. NGOs can also access a wide variety of evidence that can help outline chain of command and identify perpetrators of gross human rights violations. Global Affairs should be working more closely with our group and others in the identification of evidence and perpetrators to be sanctioned. Second, more needs to be done to support justice efforts of Tamils, both in the form of additional sanctions and additional accountability efforts through various international justice mechanisms. This need is evident from realities on the ground. Sri Lankan officials continue to arbitrarily detain individuals under the Draconian Prevention of Terrorism Act. There is a continued military presence in the north and east of Sri Lanka, and individuals are prevented from participating in peaceful demonstration and acts of memorialization. Most recently, in the wake of alarming discoveries of multiple mass graves, the Sri Lankan government refuses to allow independent and international investigations and is willfully destroying evidence. These continued abuses highlight the need to expand the current sanctions. The vast majority of Sri Lankan officials with responsibility for gross human rights violations are still not held to account. Pervasive impunity encourages continued abuses. To combat this, sanctions must be extended to numerous additional personnel with responsibility for human rights violations, and any assets held by sanctioned individuals in Canada should be repurposed to compensate victims. Canada should also engage multilaterally to press for sanctions to be implemented in further jurisdictions. Canada should be investigating how it may be inadvertently undermining its own sanctions regime by still providing funds to the Sri Lankan military through agencies like the IMF and the World Bank. Further, targeted sanctions on their own are not enough. The utilization of the Magnitsky Act, or CEMA, is one tool among many that, when used in concert, may provide meaningful measures of justice and accountability. The utilization of international justice mechanisms is important. Sri Lanka and Canada are both state parties to numerous treaties, including the Genocide Convention and the Convention Against Torture, that enable the International Court of Justice to settle disputes. The International Criminal Court may open a preliminary examination into crimes against humanity committed against Tamils on the territories of state parties. Canada should work to support these and other initiatives. We look forward to building on these engagements with this committee and would like to emphasize that the sanctions regime should be the first step in holding individuals accountable for gross violations. Canada needs to explore and implement additional measures, as this was also the recommendation of the United Nations High Commissioner's comprehensive report in 2022 that cited TRG's ICC submission. On behalf of Tamil Rights Group, thank you, and I look forward to your questions.
Thank you very, very much, Ms. Nagendra. We next go to Mr. Herman. Mr. Herman, you have 5 minutes for your opening remarks. Please proceed.
Thank you very much, Mr. Chairman. Merci beaucoup, Monsieur le Président. Je suis très content de...
Thank you very much, Mr. Chair. I'm very happy to be here today to make a few comments on the study that you're undertaking.
Mr. Chairman, it's a pleasure to be appearing before you as chair. Members may not know, but before Chairman Assassi entered the world of politics, he was a well-known trade lawyer himself, and he and I had a lot to do in the old days when we were dealing with various trade law matters. So it's a double pleasure for me to be appearing today. I'm going to address one issue, and we can discuss it further during the question period. My understanding is that the committee is looking at the government's implementation of the 2017 recommendations by this committee regarding Canada's Sanctions Committee. The standing order talks about the committee reviewing the government's implementation of the recommendations in the 2017 report. And there's one recommendation that I want to address because I don't think the government has done anything in implementing that recommendation. And that recommendation in the 2017 report, recommendation number 4, is that the government should provide comprehensive, politically available written guidance to the public and private sectors regarding the interpretation of sanctions regulations in order to maximize compliance. If you stand back and think about sanctions, they have, in the last number of years, emerged as a major element in our international relations, affecting business relations, commercial transactions in a major way. And the private sector, the business community, is in need of greater transparency and greater guidance from the government itself. In the comments that I provided to the committee, and I believe they've been translated and circulated, I made a number of recommendations, and those are, I might say, very close to the same recommendations I made to the Senate committee when it was looking at this very issue earlier in the year. And I set out a number of points that the government could address in making the sanctions regime more transparent, more understandable, and providing some necessary guidance to the business community that are often dealing with this very tricky and increasingly complex area of sanctions. And those, I won't read them, those are before the committee, but there is a need for follow-up to the 2017 report. The same recommendations are made in the Senate committee report of May of this year. And as far as I can tell through my own research, nothing has been done to improve or enhance guidance and transparency and how the government implements the sanctions regime. And that includes sanctions under the Magnitsky Act, as well as the United Nations Act, and of course the Special Economic Measures Act, which is the principal vehicle for Canada's sanctions regime. So let me leave it at that, and we can come back during the questions from committee members. J'aimerais aussi dire que
I would also like to say that I'm willing to answer questions on my recommendations in the written comments that have already been submitted to the committee. Thank you.
Very much, Mr. Herman. We will now go to questions from the members. First, we have Mr. Chong. For this round, each member will be provided 5 minutes. Mr. Chong.
Thank you, Mr. Chair. I'd like to direct my questions to Mr. Herman. Mr. Herman, nice to finally meet you, albeit not in person, but virtually. I just have your brief in front of me, and I'd like to focus on what you've talked about, which is enforcement. We can enact all the sanctions we want, but if they're not being enforced, they're of little effect. And as you pointed out, the 2017 report of this committee provided a recommendation to the government. When I look at the Canada Revenue Agency, they have a whole directorate set up to tax rulings and technical interpretations that you can access in order to get complex questions answered that will help guide your tax planning, whether it's for individuals or corporations or trusts. I think something like that needs to be set up within Global Affairs Canada to do exactly the same thing. Do you agree?
I certainly do agree. I think that to some extent it's a question of resources, but I think within the existing resources in the department, much more could be done to do the same kinds of things as you mentioned, Mr. Chong, that are done by Revenue Canada, by the CRA, and I should say the Canada Border Services Agency, when they in terms of enforcing customs laws and regulations, they provide detailed guidance, not legal interpretations, because the government doesn't provide legal advice, it shouldn't. But certainly the government could do, or the Global Affairs could do much more to approximate the same sorts of things that the Canada Border Services Agency or that Finance Canada does in terms of some policy guidance, which would, as I have to emphasize, these are matters of Canada's interests in international business. And if the business community has problems in, finding its way through these very tricky sanctions issues, it behooves the government to provide some policy guidance. Just like the U.S. administration does, the British administration, the Australian government, they provide the kind of guidance that I'm talking about, but Canada regrettably does not.
You mentioned the Canada Border Services Agency. Closely related to sanctions are our obligations under domestic and international law when it comes to preventing the importation of goods produced using forced labor. And being such a trade expert, I'm wondering if you could comment as to why CBSA, the Canada Border Services Agency, has been unable to interdict and seize and block shipments produced using Uyghur forced labor. As you know, 23.6 of the CUSMA agreement, which came into force in the summer of 2020, bans under Canadian law the importation of those goods, but to date only one shipment has been seized, and then it was later released to go into Canada. But the Department of U.S. Customs and Border Protection has interdicted and seized and blocked some 2,500 shipments since the USMCA came into force in that country. Why are we unable to match their enforcement levels?
Mr. Chong, ultimately comes down to money and resources. I think the CBSA does a very good job within their existing resources of trying to look at, examine, interdict, capture goods coming into the country. But, there are hundreds of thousands of containers that land in Vancouver. And it is very difficult, even, physically very difficult for the Canada Border Services Agency to check all of those and to look at all of the documentation related to those importations. And, look, it's a question of resources. So what do we want to do? How much is the government prepared to allocate to ensure that we can enforce those kinds of sanctions? And I agree with you. It is somewhat embarrassing to see how aggressively the United States, they're the most aggressive when it comes to border matters, but how aggressively they manage to enforce sanctions, and rather how tepid our apparent enforcement is. So I think it's a question of resources.
Thank you, Mr. Chair.
Thank you, Mr. Chong. We now go to Mr. Zuberi. Mr. Zuberi, you have 5 minutes.
Thank you, Mr. Chair. And welcome again to everybody, all the new committee members. I'd like to thank the witnesses for being here today and for taking the time. Just to reset what we're talking about with respect to sanctions regimes, and it's been a long time since we actually discussed this issue, a whole summer, and I'm happy that we're coming to a conclusion with respect to this study. When it comes to CIMA, it is a sanctions regime that applies to individuals, entities, and states, that includes an asset freeze. Import exports are also implicated and can be seized and stopped. Also, the Magnitsky essentially is kind of a layer on top of that, which applies to individuals who have committed gross and serious human rights abuses. So it basically applies, it is CIMA, but with a specific application through human rights lens to really target individuals. And so just to kind of reset the room and frame what we're talking about with respect to this study. I'd like to focus my questions to your organization, and I'm happy that we as a government have actually imposed for important sanctions on prominent individuals who were involved in the Tamil genocide, including 2 previous leaders of Sri Lanka. That was a very important moment for Canada, but also for justice and human rights, dignity, respect for the Tamil people. I'd like to ask you, what are your thoughts on focusing, in addition to sanctions, moving beyond that? Some organizations like the People for Equality and Relief in Sri Lanka, Pearl, have said that we should, in addition to and from sanctions, move beyond to supporting victim-centric international justice mechanisms. Do you have any thoughts on that?
We share that same thought as well, and as I mentioned in my remarks, sanctions are only the beginning in that process for victims and for justice and accountability. And I believe that it is important that the sanctions help strengthen these international justice mechanisms for victims to receive justice and accountability. So when work at Tamil Rights Group is taking a case or filing a case under universal jurisdiction, and the particular individual that's already been sanctioned in Canada in regards to the Trincomalee 11 murders, it really helps us in our case to say, Canada has already sanctioned this individual, and we'd like to bring him to a criminal proceeding under universal jurisdiction in another case. So this is why we feel that sanctions go hand in hand with international justice mechanisms, and we feel that yes, we can't have everybody on that sanctions list. It's not a reasonable request, and I understand that. But there are other individuals, significant individuals, who should be on that list, and that's where the role of NGOs and civil society plays to help identify who those individuals are.
And we've heard in this committee already, in this study, that civil society organizations play an important role in terms of helping us as a government and a country identify potential names for to be sanctioned. So your point echoes what we've already heard in testimony thus far. You touched upon a crime in your testimony just now. Can you elaborate upon that a bit more?
In regards to the individual?
I forget the term you used, but there was a particular crime you just talked about a moment with respect to the Tamil people.
I'm referring to there are 4 people currently sanctioned under the CIMA Act. One of the individuals was an Army general who was involved in the murder of 11 individuals in a town called Trincomalee. So that's what I was referring to in that particular situation.
Thank you. And I'd like to just touch upon field research. Do you have any? Can you shed any light in terms of the field research? What has been shown thus far within the crimes towards the Tamil people? What has the field research shown thus far from all the information you have?
So our field research and with our connections with civil society on the ground in Sri Lanka shows that since the sanctions were placed in January, the culture of impunity has not changed in Sri Lanka. As I mentioned, just most recently last week, there was a memorialization event of an individual who died in a hunger strike 36 years ago, and that memorial event was attacked with rocks, and the actual member of parliament in Sri Lanka was also attacked, and it was the police and army officials were just standing around watching. There are continuous land grabbing that's happening. Traditional Tamil homelands, Hindu temples are being erased with Buddhist temples. And so this is a structural genocide that's continuing to occur and hasn't helped the situation and is continuing to grow. So there is concern from civil society on the ground that this could continue to escalate.
A very
further.
important point. And I'd
Thank
like to
you,
just...
Mr. Zuberi. You're considerably over time, 40 seconds.